The H-1B is a non-immigrant visa in the United States under the Immigration and Nationality Act, Section 101. It allows U.S. employers to temporarily employ foreign workers in specialty occupations. If a foreign worker in H-1B status quits or is dismissed from the sponsoring employer, the worker must either apply for and be granted a change of status to another non-immigrant status, find another employer, or leave the U.S. The regulations define a specialty occupation as requiring theoretical and practical application of a body of highly specialized knowledge in a field of human endeavor including but not limited to biotechnology, chemistry, architecture, engineering, mathematics, physical sciences, social sciences, medicine and health, education, law, accounting, business specialties, theology, and the arts, and requiring the attainment of a bachelor's degree or its equivalent as a minimum. Likewise, the foreign worker must possess at least a bachelor's degree or its equivalent and state licensure, if required to practice in that field. H-1B work authorization is strictly limited to employment by the sponsoring employer. Structure of the program. Duration of stay. The duration of stay is 3 years, extendable to 6 years. An exception to maximum length of stay applies in certain circumstances if a visa holder has submitted an I-140 immigrant petition or a labor certification prior to their 5th-year anniversary of having the H-1B visa. They are entitled to renew their H-1B visa in 1-year or 3-year increments until her decision has been rendered on their application for permanent residence. If the visa holder has an approved I-140 immigrant petition, but is unable to initiate the final step of the green card process due to their priority date not being current, they may be entitled to a 3-year extension of their H-1B visa. This exception originated with the American Competitiveness in the 21st Century Act of 2000. The maximum duration of the H-1B visa is 10 years for exceptional United States Department of Defense project-related work. H-1B holders who want to continue to work in the U.S. after 6 years, but who have not obtained permanent residency status, must remain outside of the U.S. for 1 year before reapplying for another H-1B visa. Despite a limit on length of stay, no requirement exists that the individual remain for any period in the job the visa was originally issued for. This is known as H-1B portability or transfer, provided the new employer sponsors another H-1B visa, which may or may not be subjected to the quota. Under current law, H-1B visa has no stipulated grace period in the event the employer-employee relationship ceases to exist. Congressional yearly numerical cap and exemptions. The current law limits to 65,000 the number of foreign nationals who may be issued a visa or otherwise provided H-1B status each fiscal year. Laws exempt up to 20,000 foreign nationals holding a master's or higher degree from U.S. universities from the cap on H-1B visas. In addition, excluded from the ceiling are all H-1B non-immigrants who work at universities, non-profit research facilities associated with universities, and government research facilities. Universities can employ an unlimited number of foreign workers as cap-exempt. This also means that contractors working at but not directly employed by the institutions may be exempt from the cap as well. Free trade agreements carve out 1,400 H-1B1 visas for Chilean nationals and 5,400 H-1B1 visas for Singapore nationals. However, if these reserved visas are not used, then they are made available in the next fiscal year to applicants from other countries. Due to these unlimited exemptions and rollovers, the number of H-1B visas issued each year is significantly more than the 65,000 cap. with 117,828 having been issued in FY 2,10,129,552 in FY 2011, and 135,991 in FY 2012. The United States Citizenship and Immigration Services starts accepting applications on the first business day of April for visas that count against the fiscal year starting in October. For instance, H-1B visa applications that count against the FY 2013 cap could be submitted starting from Monday, 2012 April 2nd. USCIS accepts H-1B visa applications no more than 6 months in advance of the requested start date. Beneficiaries not subject to the annual cap are those who currently hold cap-subject H-1B status or have held cap-subject H-1B status at some point in the past 6 years. Tax status of H-1B workers. The taxation of income for H-1B employees depends on whether they are categorized as either non-resident aliens or resident aliens for tax purposes. A non-resident alien for tax purposes is only taxed on income from the United States, while a resident alien for tax purposes is taxed on all income, including income from outside the U.S. The classification is determined based on the substantial presence test. If the substantial presence test indicates that the H-1B visa holder is a resident, then income taxation is like any other U.S. person and may be filed using Form 1040 and the necessary schedules. Otherwise, the visa holder must file as a non-resident alien using Tax Form 104-ONR or 104-ONREZ. He or she may claim benefit from tax treaties if they exist between the United States and the visa holder's country of citizenship. Persons in their first year in the U.S. may choose to be considered a resident for taxation purposes for the entire year, and must pay taxes on their worldwide income for that year. This first-year choice is described in IRS Publication 519 and can only be made once in a person's lifetime. A spouse, regardless of visa status, must include a valid individual taxpayer identification number or social security number on a joint tax return with the H-1B holder. Tax filing rules for H-1B holders may be complex, depending on the individual situation. Besides consulting a professional tax preparer knowledgeable about the rules for foreigners, the IRS Publication 519, U.S. Tax Guide for Aliens may be consulted. Apart from state and federal taxes, H-1B visa holders pay Medicare and Social Security taxes, and are eligible for Social Security benefits. H-1B and legal immigration. Even though the H-1B visa is a non-immigrant visa, it is one of the few visa categories recognized as dual intent, meaning an H-1B holder can have legal immigration intent while still a holder of the visa. In the past, the employment-based green card process used to take only a few years, less than the duration of the H-1B visa itself. However, in recent times the legal employment-based immigration process has backlogged and retrogressed to the extent that it now takes many years for guest work visa holders from certain countries to obtain green cards. Since the duration of the H-1B visa hasn't changed, this has meant that many more H-1B visa holders must renew their visas in 1 or 3-year increments for continued legal status while their green card application is in process. Dependents of H-1B visa holders. H-1B visa holders can bring immediate family members to the U.S. under the H-4 visa category as dependents. An H-4 visa holder may remain in the U.S. as long as the H-1B visa holder retains legal status. An H-4 visa holder is not eligible to work or get a Social Security number. However, a DHS ruling made on February 24, 2015 provides certain H-4 visa holders with eligibility to work. Starting May 26, 2015, an H-4 visa holder may attend school, get a driver's license, and open a bank account in the U.S. To claim a dependent on a tax return or file a joint tax return, the dependent must obtain an individual tax identification number, which is only used for tax filing purposes. Administrative processing: when an H-1B worker goes outside of U.S. for vacation, he or she has to get the visa stamped on his passport unless he has already done so for re-entry in the United States. The interview is taken in U.S. Embassy by a visa officer. In some cases, H-1B workers can be required to undergo administrative processing, involving extra, lengthy background checks. Under current rules, these checks are supposed to take 10 days or less, but in some cases, have lasted years. Application process: the process of getting a H-1B visa has 3 stages. The employer files with the United States Department of Labor a labor condition application for the employee, making relevant attestations, including attestations about wages and working conditions. With an approved LCA, the employer files a Form I-129 requesting H-1B classification for the worker. This must be accompanied by necessary supporting documents and fees. Once the Form I-129 is approved, the worker may begin working with the H-1B classification on or after the indicated start date of the job. If already physically present in the United States, invalid status at the time. If the employee is outside the United States, he/she may use the approved Form I-129 and supporting documents to apply for the H-1B visa. With an H-1B visa, the worker may present himself or herself at a United States port of entry seeking admission to the United States, and get an Form I-94 to enter the United States. Employees who started a job on H-1B status without a H-1B visa because they were already in the United States still need to get a H-1B visa if they ever leave and wish to re-enter the United States while on H-1B status. Opt-Cap-Gap extension for STEM students. For more details on this topic, see Global Labor Arbitrage, STEM-eligible degrees in the U.S. Immigration and Optional Practical Training. On April 2, 2008, the U.S. Department of Homeland Security Secretary Michael Chertoff announced a 17-month extension to the opt for students in qualifying STEM fields, also known as the Cap Gap. The rule change allows foreign STEM students opportunities unavailable to foreign students of other disciplines. The 17-month work authorization extension allows the foreign STEM student to work up to 29 months under the student visa, allowing the STEM student multiple years to obtain an H-1B visa. To be eligible for the 12-month permit, any degree in any field of studies is valid. For the 17-month opt extension, a student must have received a science, technology, engineering, or mathematics degree in one of the following approved majors listed on the USCIS website. In 2014, a federal court denied the government's motion to dismiss the Washington Alliance of Technology Workers and 3 other plaintiffs' case against the opt extension. Judge Hovell noted that the plaintiffs had standing due to increased competition in the field, that the opt participation had ballooned from 28,500 in 2008 to 123,000, and that while the students are working under opt-on student visas, employers are not required to pay Social Security and Medicare contributions, nor prevailing wage.